DeGrechie is self-represented and is appearing by phone. Representing the Applee Department of Labor is Attorney Jared Adler.
Thank you very much, and good morning again, everybody. Mr. DeGrechie, can you hear me, sir?
Yes, I can, sir.
Good. We can hear you as well. You understand you have 5 minutes?
Yep.
Okay. Go ahead, please.
Okay. In November, I was called into the office on a Monday. I thought I was going in there to be given a new assignment for a job. I was let go due to tardiness. I had never been late for work before. Then I was out of work quite a bit. I had 2 weeks that were 2 different times I had COVID, and then I had some ulcer issues. And I couldn't miss very much time with Chuck because I had 180 hours of vacation time accumulated. And then, it states that my absences were unexcused. Well, I called in sick. I let my superiors know every time I was not going to be in. So I don't know how they can say that this is unexcused. I can't it says I needed to give 2 weeks notice. Well, I can't give 2 weeks notice when I was out sick. They also stated here that I had a conflict with a coworker. This was not at work. It was on off hours, and we had a spat in the hotel room, which we were staying at. We worked 4 days a week, and so I had a spat with him, and that was on not on work hours. So as far as I know, I should not be accountable for anything that would be happening off work hours. I don't work for the military where they own you, so I have a big issue with that. Let's see. Then they stated somewhere here that I was down at the hotel room and not working that we stayed at in White River. I worked that week, Tuesday through Friday, and I was down there on a Monday. I was buying a new home at White River Junction. So that's why I was there, and it says that I was there several times without working. Not true. And as far as these warnings go, I have never heard a warning from this company. Not from my coworkers, not from Dave Langlois, and not from Carla Roy. It was a big shock to me when I was told I was let go. If I'd ever had a warning, I've been in the construction business for 30 years. If I'd have had a warning, I had a good job there. If I would have had a warning, things would have been different. At the time, we were slow, and I wasn't feeling well. I was very sick. And I called in every time and used up my vacation time, or as they call it now, paid time off. Again, I accumulated that vacation time because I never missed work. And it says about vacation time, I never took vacation time. I never took vacation time once with Chuck as far as a vacation goes. They let you use your accumulated hours to make up a 40-hour week. And that's what happened with me. It says, again, that I was frequently absent, and it was an issue. And also, I see a note, a letter here from my coworker, David Bushy. Says that that he didn't give me COVID. Well, in fact, he was on the job site, him and his worker that ride together every single day.
Remaining.
Mr. DeGrechie, you've got 1 minute.
Okay. He was coughing all the time. I mentioned to him, and Carla Roy, our HR lady, made them go to get tested, and they were tested positive. So he was the start of this COVID thing. But anyways, that's my story. That's what happened. I swear to tell the whole truth, and
All right.
this is God's honest truth.
Okay,
I
you can
admit that-
reserve the rest of your time if you like. You can reserve it.
No, I'm good. I'm good.
All right. Thank you. We'll hear from counsel for the appellee. Please identify yourself, your client, and then proceed.
Thank you. Good morning, Your Honors. My name is Jared Adler for the appellee, the Department of Labor, and may it please the court. The decision of the Employment Security Board should be affirmed because credible evidence in the record supports the board's conclusion finding disqualifying misconduct on the part of the appellant. All interested parties here, the appellant and two representatives from the employer, participated in the evidentiary hearing before the administrative law judge and in the hearing before the Employment Security Board. So both bodies had the benefit of testimony from parties that they could weigh in issuing their decisions. The board's conclusion that the employer discharged the appellant for misconduct is supported by sworn testimony from the employer and documentary evidence in the record. First, the board correctly concluded that appellant's absenteeism constitutes disqualifying misconduct. The record establishes that appellant accumulated approximately 16 unexcused absences between August and November of 2022. I understand that there's some dispute about maybe what the absences were attributable to. However, if you refer to page 31 of the appellate volume, this is an accounting of the appellant's attendance record, and there is some delineation between the types of absences in that attendance record. And as you can see, some are designated as unexcused absences, and there is a separate category for sick absences. So I suppose even if some of the appellant's absences were attributable to illness that was outside of his control, some of them, it seems, were not, because they were designated as unexcused absences that were not designated as sick absences in his attendance record. The employer considered absences to be unexcused when the appellant did not provide proper notice according to their workplace policies. And, this policy about absenteeism provided that the appellant could face discipline up to and including termination without prior warning or prior counseling. And the employer testified that the appellant's absences and his lack of notice when he was missing work was creating scheduling and coverage problems for projects that appellant was scheduled to work on. The employer testified that they discussed these issues about providing proper notice when he was going to be absent. And this is found on pages 15 and 23 of the transcript before the administrative law judge. The board correctly concluded that appellant's absenteeism was a willful disregard of the employer's interest, and that conclusion is supported by credible evidence in the record that establishes that the appellant received counseling from the employer about these issues, and that the issues were creating hardships for the business in terms of having a reliable workforce that was going to be available on scheduled projects. Second, the appellant's violation of a workplace policy against disparagement of coworkers also constitutes disqualifying misconduct. Credible evidence in the record is undisputed that appellant yelled at his subordinate while they were away on employer-provided accommodations on a work project. And appellant argues that this conduct occurred off hours, and so it shouldn't be considered to be misconduct. However, even though he may not have been working when this conflict occurred, he was away on a work project. He was staying in employer-provided accommodation here, and he was sharing this accommodation with a subordinate. This conflict caused the subordinate to abandon the work project. So even if it technically wasn't during working hours, it had a direct impact on the employer's business, as this coworker abandoned the work project, and the employer presumably would have to find coverage for this individual who was scheduled to be performing work on this project. I'll also just point the court to page 29 of the appellate volume, which contains the employer's policies prohibiting disparagement and disrespect of coworkers. The appellant acknowledged these policies and signed his acknowledgement when he began working in 2018. And these policies provide a description of the possible discipline that employees could face upon violation. And again, they provide that discipline could be including termination without any prior warning or prior counseling. So for these reasons, the decision of the Employment Security Board should be affirmed, and I'm happy to answer any questions from the court at this time. Thank you.
Well, your time has expired. Thank you very much. How much time does the appellant have, please?
Appellant has 26 seconds remaining.
Okay, Mr. DeGrechie.
Again, these warnings were never given to me from my employer about unexcused absences. I would have corrected those things. As I said, I've been an employee and a valued employee of theirs. In fact, a couple letter of accommodations have come into Chuck's from me when I worked at the VA hospital for them. So there's other issues of why they let me go that's not there. That's all I can say.
Okay. Thank you very much. Please call a conclusion.